Hello everyone. The next short note is on independence of the judiciary. Independence of the judiciary is a foundational principle of constitutional governance, essential for maintaining the rule of law, safeguarding rights, and ensuring fair and impartial justice. It implies that judiciary must function free from interference by the executive, legislature, or any other external pressure. Meaning of judicial independence. Judicial independence means the judges must be free to decide cases solely on the basis of law and facts without fear, favor, influence, or pressure. This autonomy exists both at the institutional level, independence of the judiciary as a body, and at the individual level, independence of each judge. There is no liberty if the judiciary is not independent. By Montesquieu. Importance of judicial independence: protection of fundamental rights, upholding rule of law, ensuring fair trials, maintaining public confidence in justice, check on abuse of power by other organs, peaceful resolution of disputes, constitutional provisions ensuring judicial independence in India. India's constitution contains structural, procedural, and institutional safeguards for judicial independence. First, separation of powers. Article 50 directs the state to separate the judiciary from the executive in public services. Second, security of tenure. Article 124 and 217. Judges of the Supreme Court and High Courts cannot be removed except by impeachment on grounds of proven misbehavior or incapacity. Third, fixed service conditions. Salaries, pensions, and privileges of judges are charged on the Consolidated Fund of India and not subject to parliamentary vote. Fourth, independent appointment process. Judges are appointed through the collegium system, reducing executive influence. Fifth, restriction on post-retirement jobs. To prevent bias, Supreme Court judges are barred from taking post-retirement employment in government except in rare cases like tribunals or ad hoc appointments. Sixth, powers of contempt. Article 129 and 215. The judiciary can punish for contempt to preserve its authority and dignity. Seventh, judicial review power. Article 13, 32 and 226 ensures that legislative and executive actions remain within constitutional limits. Judicial pronouncements on judicial independence. The first case is S.P. Gupta versus Union of India, 1981. Recognized independence as a necessary component of judicial functioning, though upheld executive primacy in appointments, later reversed. Supreme Court Advocates on Record Association versus Union of India, 1993. Established the collegium system, emphasizing that primacy in appointments must rest with the judiciary to maintain independence. Keshwananda Bharti versus State of Kerala, 1973. Declared judicial review and independence of the judiciary as part of the basic structure of the constitution. Indira Nehru Gandhi versus Raj Nareen, 1975, reaffirmed that judicial independence is vital to constitutional democracy. Threats and challenges to judicial independence: executive interference, pressure on judiciary through transfers, delayed appointments, or criticism. Second, politicization of appointments, lack of transparency in the collegium system has also led to accusation of favoritism. Third, post-retirement alertments. Appointing retired judges to political or executive posts may compromise their impartiality. Fourth, media trials and public pressure. Media influence can affect perception and independence in high-profile cases. Measures to strengthen judicial independence: transparent appointment mechanism, reforms in the collegium system, or a well-structured NJAC, National Judicial Appointments Commission. Second, strengthening institutional autonomy, financial and administrative autonomy for courts, code of conduct for judges to ensure integrity and avoid conflict of interest. Fourth, judicial accountability framework without compromising independence. Fifth, regulating post-retirement appointments to avoid bias during tenure. The conclusion is judicial independence is not just a theoretical idea but a practical necessity for ensuring justice, equality, and democracy. In India, it serves as the last line of defense for citizens against unconstitutional or arbitrary actions. However, independence must be balanced with accountability to maintain public trust and institutional legitimacy. The hallmark of a truly democratic society is a fearless and independent judiciary by Justice V.R. Krishna Iyer. Now, the next short note is on institutional liability of courts, scope and limits. Introduction. Courts are vital institutions in a constitutional democracy entrusted with the administration of justice, interpretation of laws, and protection of fundamental rights. However, with such immense power comes the expectation of accountability. The concept of institutional liability of courts deals with responsibility of the judiciary as an institution for its actions or omissions, especially when such actions may result in injustice or harm to individuals. This concept raises critical questions about the balance between judicial independence and judicial accountability and explores how far courts can be held institutionally liable and what limits are constitutionally or practically imposed on this liability. Meaning of institutional liability of courts. Institutional liability refers to the legal and moral responsibility of the judiciary as an institution, not individual judges per se, for unjust judicial decisions, delays in justice delivery, administrative lapses in courts' functionings, violation of fundamental rights, example delay in bail or trial, misuse of judicial power. It does not usually imply personal liability of judges but emphasizes systematic accountability of the judicial institution as a whole. Constitutional and legal framework. Judicial immunity, Article 124 and 217. Judges of the higher judiciary enjoy immunity from civil and criminal liability for acts done in the exercise of their judicial functions. This protects judicial independence, ensuring judges act without fear of retribution. Contempt of Courts Act 1971 provides courts the power to punish for contempt but also imposes a duty of fairness and restraint. Misuse of contempt powers can itself raise issues of institutional overreach. Article 32 and Article 226. Citizens can approach courts for enforcement of fundamental rights. However, what recourse is available when courts themselves are the violators? Scope of institutional liability of courts. Delays in justice delivery. Justice delayed is justice denied. Courts may be institutionally liable for inordinate delays that led to miscarriage of justice. Example, Hussain Ara Khatun vs. State of Bihar. Delay in trial was held to violate Article 21. Wrongful detention or conviction. Courts have a duty to protect liberty. Failure to grant bail, non-hearing of habeas corpus, or wrongful conviction due to systematic negligence can raise institutional liability. Example, Bablu Chauhan vs. State Delhi. Compensation awarded to a person wrongfully incarcerated for 11 years. Administrative failures. Malfunctioning courts registries, missing case files, or mismanagement of court proceedings reflect institutional liability. Example, imposition of costs on courts by higher judiciary in cases of administrative delays. Fourth, denial of access to justice. Denying parties timely hearing or accessibility, physical or economic barriers may amount to violation of constitutional rights under Article 14 and 29. Violation of fundamental rights by judicial orders. Though rare, judicial orders may infringe fundamental rights and can be challenged via curative petitions or review petitions. Example, ADM Jabalpur case, later criticized for allowing suspension of fundamental rights during emergency. Limits to institutional liability. Judicial immunity. Judges are not personally liable for acts within their judicial capacity. Ensures unfettered judicial decision making without fear or consequences. Finality of judicial decisions. Once a judgment is passed and reviewed or appealed, courts are not liable for any consequences flowing from it, even if it is later overturned. Contempt power shields courts. Criticisms of courts can be restricted under contempt laws, limiting open discussion of judicial errors. No statutory compensation mechanism. India lacks a comprehensive legal framework for compensating victims of judicial errors, unlike in some Western jurisdictions. Separation of powers. Courts cannot be subject to oversight by the executive or legislature in judicial matters, limiting external checks. Comparative jurisprudence. United Kingdom. Judicial immunity is recognized, but judicial review of court administration is permitted in limited cases. United States. Strong tradition of judicial immunity, but also recognition of civil rights violations by judicial officers in egregious cases. European Convention on Human Rights enforces accountability if a member state's judiciary violates the right to fair trial or liberty. The conclusion. The institutional liability of courts is a sensitive yet important issue in a constitutional democracy. While judicial independence is crucial for impartial adjudication, it must be balanced with accountability to prevent the judiciary from becoming unquestionable and unaccountable. The scope of such liability in India remains limited, but more moral and administrative than legal, owing to immunity doctrines and lack of clear statutory mechanisms. However, in an era where access to justice and rule of law are paramount, there is a growing demand for institutional mechanisms to review judicial conduct, redress judicial wrongs, and maintain public confidence in the judiciary. Thank you.